Hello, everyone. Good evening. My name is Rebecca, and I'm an event planner with the Orange County Library System. Welcome to tonight's virtual event, Ask a Lawyer, presented by the Orange County Bar Association. In tonight's event, you'll have the opportunity to speak with a panel of attorneys to get insight and guidance on estate planning, wills, and probate. Before we begin, I would like to share a couple things about Zoom. Please keep in mind that everyone's videos besides our speakers will be turned off. You will be muted unless you are asking a question, and then you may unmute yourself. If you have a question and would like to speak, please use the raise your hand feature. At the bottom of your screen, if you click on the reactions button, you can see the raise your hand feature. Also at the bottom of your screen, you'll see a chat feature. I'll be using the chat to list by number and name whose turn it is next. So don't feel like you have to write your name or put yourself in line. Just say that you have a question and I'll be numbering that list. Please respect others and wait to be called on. We want to avoid people speaking out unless it is your turn. If you speak out of turn, you will be muted. For those of you who are calling in, if you want to speak, press the unmute button and I'll see it and we'll add you to the numbered list of who to call on next. Once myself or the moderator calls on you, then you may speak. Without further ado, I'd like to begin by introducing Vanessa Clark, our moderator for tonight's event. Thank you so much for joining us tonight. I'm going to go ahead and turn it over to you, Vanessa.
Thank you, Rebecca. Good evening. My name is Vanessa Clark of Clark Law PLLC, and I am a member of the Orange County Bar Association. I'd like to thank you for attending our Ask a Lawyer event sponsored by the Orange County Bar Association and the Orange County Clerk of Courts. Before we get started, allow me to give you a little background about the Orange County Bar. The association has been around for 85 years. In addition to serving the needs of our members, one of our goals has been to reach out into the community and provide services and programs that will benefit Central Floridians. Some of our programs include our members' pro bono work with the Legal Aid Society of the Orange County Bar Association, our lawyer referral and information service, our Law Week program for school children of Orange County, and our free citizen dispute and family law mediation program. The citizen dispute and family law mediations are facilitated by an impartial professional mediator who listens to both parties and encourages a resolution that is satisfactory to both parties. This is a free program for anyone residing in Orange County. Tonight's Ask a Lawyer event is just one of these programs, and we hope you feel free to ask any questions you have about estate planning, wills, and probate. Orange County Bar attorneys Meenakshi Hirani of Meenakshi Hirani, PA, Skiles Jones of Patriot Legal Group, and myself will help guide you through some of the issues that you want to know about. Tonight's event will be recorded and shared on the Orange County Bar Association's Facebook page. Please be sure to like the page if you are on Facebook. I would now like to introduce Ms. Vanya Atkinson, Operations Assistant Manager of the Self-Help Center, to speak about the Orange County Self-Help Center.
Thank you so much. Welcome, everyone. I hope you are enjoying your evening. I'm here to speak about the Self-Help Center and just talk about a few things that what we do. Let me share my screen. Okay. All right. Okay, so here we go. All right, so just a brief quickness about what kind of case types we handle at the Self-Help Center. We only handle civil and family cases. Not all civil cases, but only evictions and small claims up to $8,000 only. In regards to family cases, besides injunctions, we do not do injunctions there. We do anything from dissolution of marriage, paternity, name changes, step-parent adoption, and temporary custody. As most of you might not know, that the Self-Help Center was opened in 2015, and it was dedicated to our late clerk, Lydia Gardner. And our Self-Help Center assists the underserved customers who don't have legal representations. We do have virtual attorney consultations. We are located at the downtown courthouse on the 3rd floor, and we're open Monday through Friday, 7:30 to 4. Some of the services that we provide are, like I said before, virtual attorney consultations. We do not have any in-person at the moment, but they're all through Zoom. We sell forms and we assist in completing the forms. We are not attorneys, the clerks that work there, so we don't, we can't give legal advice. So we can guide you and assist you in filling out the forms. We also have notary and copy services for court-related businesses, landlord tenant guidance. And we also have several computers in the Self-Help Center for your convenience to look up any kind of court-related business. Like I said, we do virtual attorney consultations through Zoom. The appointments can be made online with a credit card, which includes a $1.50 convenience fee. You're more than welcome to come physically into the Self-Help Center and schedule an appointment. However, we do accept cash only for the appointments. The attorney appointments are $1 a minute and in 15-minute increments, and it's up to 60 minutes per day. Once you schedule your appointment, you will receive a Zoom link the day before your appointment. So sometimes it's not as in your inbox, and sometimes you might have to look in your spam or junk or, stuff like that. So like I said, we do sell packets. We do sell small claims packets up, like I said, to $8,000. And they're $2 a packet, depending on the amount that you want to do the small claims in. Also, the eviction packets are $10, along with the filing fee and the summons fee. Now, all of the packets and filing fees, you're more than welcome to come into our office and get it and purchase it, but you can also get it online on myorangeclerk.com as well for your convenience. Same thing for family cases. You can get packets for any of the name changes, minor adults, any kind of dissolution of marriages, temporary custody, or paternity. You can pay the packet fee in our office, or you can purchase the packets online as well. Typically, when you submit your packets and your paperwork to the clerk of court, we give you a case number. And once we are done with it and we intake it, it goes to our case management. And they are the ones that look over your case and take any kind of action to it. Now, if you're missing any documents, they will reach out to you. Now, if you are wanting to reach out to them, we don't know the status of your case. So in order for you to find out the court date or a status of what's going on with your case, you have to follow the link below, the 9thcircuit.org, and just follow the prompts. And what it is you just fill out a form. It's an email. Once you do that and submit it, they will contact you within a few days with the status or whatever the question is. There's several ways to contact us. You can go on myorangeclerk.com and go to the Self-Help Center and click on Contact Self-Help Center. And that is just basically an email sent to us. Tell us your question. We'll reply back to you, or you can call us, leave a voicemail, or more than welcome to come in. We highly suggest to come prior to 3 o'clock, because a lot of these new cases are very, very lengthy, because our clerk has to go through each document and see if everything is there that needs to be filled and required. So it's a lengthy process, and it's something that's very life-altering, getting divorced or paternity. So you just don't want to come in and rush. So just take your time and fill out the paperwork. Again, our location is at the downtown courthouse, room 340 on the 3rd floor. There's our phone number. We can also schedule, you can schedule your virtual attorney appointments online as well at myorangeclerk.com. We are open from 7:30 to 4. And that is it.
Wonderful. Thank you for all of that wonderful information.
No problem.
So at this time, I will open the floor up officially for questions regarding estate planning, wills, and probate. And when I go into the chat, I do see, Rebecca, that we have a question from a Mr. Rob.
Yes. Hi, how are you?
Good for you.
Good. Trying to see if this is, I think it's probate related, but it's regarding a power of attorney. Is that still on the guidelines?
Yes, that falls within estate planning.
Okay. So I have a power of attorney is made before the 2013 update of the law in Florida. And it has a clause that says that if it has any illness, it cannot be changed. It's a durable power of attorney. So if the person has chronic depression and multiple personalities, which are not curable, will they be able to cancel that power of attorney?
So let me just make sure I heard your question correctly. You're asking if a power of attorney was signed before the change in the law in the power of attorney statute.
Right.
Since there is a clause that says the power of attorney cannot be changed if there's any subsequent incapacitation, is it still a valid power of attorney? Is that correct?
Right.
I'm going to go ahead and turn this to one of our attorneys, Skiles or Meenakshi, if one of you guys want to try and answer this question.
Okay. I'll defer to you. Yeah. Ms. Rani, go ahead.
Okay. As I understand that it cannot be changed if there is some kind of incapacity later on, and the person does want to change the power of attorney now. The person who executed
Right.
the power of attorney wants to change it.
Right. No, I'm asking if it can be changed if they wanted to change it.
Yes, if they have the capacity, they can always change it. Only thing you have, the person should be mentally capable at the time of doing so.
So even if it's durable and they are incapacitated or they're going through one of the items listed, they can still change it?
If at that time they do not have capacity, then they cannot do it. The law said there are always lucid intervals. So if during those lucid intervals, when the person is capable of understanding what they are doing, then they can do it.
Okay, thank you.
Alex, is there anything you'd like to add into that?
I think also the question was, the old power of attorney is still valid. It doesn't go away because they become incapacitated. That's what the durable power of attorney means, is that I'm currently okay to make this decision to have a power of attorney, but then later on I have a medical issue or whatever. That means later on I'm not able to make a power of attorney. That's where the durable part comes in, is that it still allows that to be in effect and allows that person to make that decision for the other person. I think what your question was is, if you've been given power of attorney by somebody else and then they become incapacitated or they're having other second thoughts, can they still change, or can they change it? And the answer to that is yes, if they still have capacity to change it, which is what Ms. Harani was saying. If they still have capacity, they can always change their power of attorney. If they don't have capacity, then they wouldn't be able to change it because they no longer have the capacity. So I hope that helps explain that question a little bit more.
Thank you.
And I'll chime in one additional item is to just make sure that the power of attorney was signed under the formalities of Florida in front of two witnesses, not related.
Yes.
Those are one of the things you always just want to double check and be sure of.
Yes.
All right, Mr. Rob, I hope that answers your question. I will ask you to go back on mute. I do see that question number 2 in the chat is Rebecca says to call on Miss Bess. Miss Bess, if you want to come off mute, if you're still here, and ask your question. I do see you, Bess, on the Zoom, but
She asked her question in the chat. So her question, this is Sarah, by the way.
okay.
What should I look for when choosing a lawyer to work on a will? And how do you tell if a lawyer is a good fit?
Skiles, do you want to go first this time?
Sure. So I'm looking at the chat. So what should I look for when choosing a lawyer to work on a will? Really, what I tell all my clients is you want to find an attorney that you can communicate with and make sure that they're going to understand your needs and understand what you're looking to do. There's a lot of attorneys out there that'll just say, oh, hi, you need a will? Sure, fill this form out. I'll fill in some blanks. Here's your form. But that may not be the right person for you. And that's whether it's a will or any other legal question you're going to have. Make sure you get the attorney that's going to be a good fit for you. It's kind of a friendship, not really, but you want to kind of have a little bit of some type of relationship with that attorney. It's a professional relationship, but you want to have a relationship where you can say things to them. They can understand what's happening, and so there's not a communication issue there. And that also answers hopefully your second question of how do you tell if it's a good fit, is that you're able to have that open communication and they're understanding what you're needing. You may not agree with what they suggest, because if they tell you, hey, if you say, here's my situation, I want to do X, and they say, based on your situation, you should probably do Y, that doesn't necessarily mean they might not be the right person, but they're just giving you what their advice would be for somebody that's in your situation. I hope that answers your question. If so, either answer or answer in the chat, or you can, I see a thank you. There we go. Okay.
And I'll go ahead and just chime in too. Other things that, if I were in your shoes and I were looking for an attorney, I would want to know what their fees are, what the compensation structure looks like. I'd want to know from them maybe a little bit of their background, how long they've been practicing. If you found them online, what are the reviews like? If they're a referral from a financial advisor or from a friend, you're going to share with them some very personal information. So you do want to make sure that you feel comfortable with them. Ms. Meenakshi, is there anything you'd like to add to that question as well?
Also, if I was a client, I would like to see that is the attorney interested in me trying to find out more information than I would be able to provide to attorney. I might just go and say, I've got 2 kids and I want everything to be distributed equally to my children. But is attorney coming forward and asking more details? How old are your kids? How educated, or is one young? Trying to find out, would one child need more support than the other? Or is one child has got some disabilities that there should be a special needs trust instead of giving the whole half share to that child outright. So I would try to see whether the attorney is just giving me, as Skiles put it, just giving me the form to fill up the information so they can go and just generate some document, but really understands my situation and tries to help me out.
Wonderful.
And it'll be for the attorney to pull out the information.
Ms. Best, I hope that answers your question. I'm going to move on to question 3 from Ms. Willia Williams, and I do see that it's 3 questions in the chat. The first is how to get started on the following: the POA, living for my mom, a living will for me and my mom, and a signed executive over my affairs upon my death, how to get started placing proper paperwork in order. I'll go ahead and just start off answering this question. One of the first things that I would recommend that you do is create a full inventory of the assets that you have and the assets that your mom have. If we're talking about estate planning, estate just being a fancy word for everything that you own. So in order to really do that, we have to figure out first, what is it that you have, and what are we planning for? Are we planning for, like, what are your goals, right? So once you know if you want to leave something to your children, to nieces, nephews, grandchildren a charity, I think the first step is just creating an inventory of your assets. Most attorneys, when you reach out to them, will have you do some type of long, detailed intake form where they ask you about what you have and about your family and about your wishes. And that's why it helps us narrow down what exactly we're dealing with. Your question also asked about a POA and executor. There's two different parts to this. A power of attorney is an advance directive. It's a document that you create while you're alive but incapacitated. So if you're alive but incapacitated, you want your agent to handle your financial affairs. A living will is also an advance directive, and it's you're alive but you're in a persistent vegetative state. You're not going to, doctors have said that you're not going to come out of this. Who essentially do you want to pull the plug? This is that Terry Schiavo document. Assigning an executive, I think what you're talking about here is naming a personal representative, and that's something that you do in a will. And the will is really more on that death planning. When you're not here, who do you want to carry out your affairs? So if the question is how you go about doing that, you would do that one in a will. I hope that answers all layers of your question, but I will ask Ms. Meenakshi if she wants to chime in, and Skiles, and then if you want to chime in too.
I was just going to piggyback to say that what we said with the last question with Bess kind of all fits with that as well. So everything Vanessa said, but how do you pick the person kind of goes along with that, because that's part of that whole estate plan. So just go through with that whole process, and part of that estate plan is kind of covering all of those documents. That's typically what we would do is kind of do them all at one time.
Ms. Meenakshi, do you want to add anything onto that one?
No, basically you both have covered everything.
Okay. I'm going to move on to number 4. Number 4 is iPhone. I'm not seeing the question from iPhone. If you want to unmute yourself and ask the question. Oh, prenuptial agreement signed and breached. Will state spouse only entitled to terms of agreement need to, I'm not quite sure.
Okay, I didn't get to finish. Can you hear me now?
I can,
I
yeah.
am muted. Okay, the prenuptial agreement needs to be litigated before the probate can continue. Is that correct? If the prenuptial agreement has been breached?
I'll take that real quick. So a prenuptial agreement wouldn't necessarily be part of the estate planning part, or the litigation involved with that is not part of what we're doing tonight. But if the person has passed away, then that would be part of the probate. So let me give you an example. So if a prenuptial agreement, and so that way you don't have to give specific details of your individual situation. But I had a prenuptial agreement that said the person that passed away was supposed to have a $100,000 life insurance policy on them payable to the ex-spouse, and they didn't do that. So the person passed away. The ex-spouse then filed a claim in the probate matter that said, hey, probate court, I was supposed to be entitled to a $100,000 life insurance policy. My ex breached our prenuptial agreement. I should be entitled to $100,000 of the estate assets. And that's done through the probate process. It can be a fairly easy process by filing claims. And if everyone's in agreement as to that's what needs to happen, no litigation for quote unquote, it needs to occur. But if they don't agree that that wasn't supposed to happen, you may need to litigate, and that should be done through the probate or in the probate process. Does that answer your question?
Yes, I've been told it needed to be in domestic relations court because they handle prenuptial agreements. We were not divorced, and then I've been told it should be in civil case court, but then I've been told it could be in probate. So I don't know where I need to go to.
I will say, once somebody has passed away, the probate court can handle just about any kind of matter in the probate process.
Oh, wonderful. Okay. Thank you so much for that response.
Sure thing. Probate has jurisdiction over anybody that has passed away and whatever their assets are.
Okay. Thank you so much.
And I'll go ahead and just chime in that Skiles is a phenomenal probate litigator. So if you're caught in a situation where you need more help, his firm is Patriot Legal Group, and I'm sure he'd be able to help.
Okay, who was that again?
Giles
Patriot
Jones-
Legal.
Yes, Giles
Yeah.
is the one who just answered your question on the.
Okay, Giles Jones. Okay, thank you so much. Giles.
I'm going to move on to question 5 from Natalie. I'm looking through the chat. I see your question. In the will, is it still legal if you don't give equal distribution to any heirs? I'm going to, Ms. Meenakshi, actually, do you want to go ahead and take this one?
Sure. It's your free will. You can give whatever you want to anybody you want, and nobody can stop you, except there is the spouses have got some rights and based on each state, whether it's a community property state or not. But for children, you can give whatever share you want to give it to them.
So what I'm asking is, me and my husband been married for over 20 years. He has children from a previous, I have a child from a previous, and I know the law says that because we have children from previous, they have rights if there's no will to the house, everything that, like, so if my husband died, his children would have rights to the house, to his whatever. So he's actually sitting next to me, and he wants to know if the will doesn't go through, if he doesn't file a will, what are my issues if the children try and come and take the house from me?
Sure. So
House-
you've got a couple of different issues, especially with the litigation aspect. The will, just like she was saying, is you can give the will to whoever, you can give your stuff to whoever you want with a few exceptions. You have to take care of your spouse to a certain extent because there's spousal elective share requirements. And you cannot give away your house, your homestead in a will other than to your spouse if you're married or if you have minor children. So if you don't have minor children and you have a will that gives, let's say your will gives the house to the spouse or to, well, if you're married, if your will gives it to your spouse and you have children of a prior marriage, but they're not minors, then you can do that and your spouse will get the house completely. Okay, they can't challenge who you're giving to in the will. They can challenge the will as to it wasn't made properly, it wasn't executed properly, there was undue influence, there was, you didn't have capacity to make the will or something like that. But they can't challenge, if it's a valid will, they can't challenge who the beneficiaries are once it's been admitted into probate.
Okay, so if we use a program that will generate a will, how do we get that certified in the courts?
Using a program like an online?
Yeah, like a
will?
computer program, like wills and trusts, whatever, and we generate a will. I generate a will, he generates a will. How do we get that into the courts? Because we've been trying to get notaries to sign and they're like, no, 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 we're not signing wills. How do we get that into the courts so that it's documented? This is what we want.
I'll go ahead, Kyle. So
Go ahead.
you don't have to register a will until the person has passed away. If you go online and you generate a will through LegalZoom or some other website, which actually does go into the next question, you are able to do that. I know they offer it for a nominal fee, but they don't provide any legal counsel. And it sounds like in your situation, what you could really benefit from is some legal counsel. Ensure that your home is titled in the right way, ensure that all of your assets are titled in the right way. If you and your husband have a very specific way that you wish to distribute your assets. What I want you to know too, and what Skiles was also alluding at is you have a blended family type situation. If you've got, both of you have kids from a previous relationship, and without a will, the laws can get, cannot be in your favor in certain points. So although you are able to generate a will, depending on your homestead, the will may or may not be able to devise the homestead. I think what would be better for your situation would be to actually speak with a lawyer one-on-one.
Thank you.
I'll one thing I like to emphasize is you do need in Florida 2 witnesses and a notary. and it has to be self-proved. So even if you generate and you say you are not getting anybody to notarize it, that will not be valid when the person passes away and it is probated.
So I guess I'll be checking in with a lawyer to actually get this completed and processed. Thank you so much. I appreciate it.
Of course. I do see that the next question is from Miss Peggy. I had it up. Is legal Zoom wills and trust an option for wills? It is an option. And what we were kind of saying earlier is you don't get any legal counsel. So depending on your specific situation, legal Zoom, Quicken Will, all those online offerings, they're good as far as like, here you go, here's a pre-generated form. But depending on your specific situation, again, they don't provide any legal counsel on what may be the best way to word certain things, what may be the best way to title things. So although, yes, it's an option, what you're going to hear, I think, from all of us is that we do recommend that you speak to an attorney to ensure the documents are signed properly, executed properly, and that everything protects your and your family's best interests. Skiles, Ms. Meenakshi, did you guys want to add anything to that?
No.
Yeah, that's perfect.
I'm going to move on to number 7. That's Ms. Carmen. I don't see your question in the chat, Ms. Carmen, if you want to unmute and ask your question.
Good evening. Do you hear me?
Yes.
Okay. I'm sorry, English is my second language, so I hope I can get through to you. I mean, that you understand me. I want to know, I am a widow and I don't have any children. I have 5 nephews and I want to leave all my assets, or 95% of my assets, to one nephew. My question is, this nephew, he might be going through, he might in the future go through a divorce. So I want a type of instrument that I give him all my assets, that this person, if they get a divorce, won't get half of whatever I leave him. So I want to know if just a testament is okay, or do I have to do something else that is called, I think, living trust or something like that?
Skiles or Meenakshi, do you guys want to take this?
Yeah, I can, or I'll go ahead.
I think to be on the safe side, it'll be better to create a trust, and there you are guaranteed that it'll go to that person only. And if there is a divorce or any other situation, it will not be divided at that time with the other spouse.
It will not be divided.
If it is in a trust.
Okay, so if it has to be a trust, not just a testament, a will testament.
Well, in the testament, it goes to him, and afterwards, who will monitor it? How will it be monitored?
Okay, I understand. So the best instrument would be a living trust. And that way, only he will get the assets. Even if he gets divorced, he keeps the assets that I give him.
Yeah, if the trust is worded properly.
Okay. Thank you very much.
Ms. Carmen, I'm into that one. I just want to note the distinction between the will and the trust. The will only says give X amount to so-and-so. So if you say on there that you want to give, we'll just say 1,000 to this specific nephew, once that money gets into his hands, that's it. It becomes, if he's married, it'll likely become part of that marital property if he commingles it. And then if there is a divorce, then it would be subject to however that divorce goes. A trust is completely different. A trust is set up to bypass probate and to ensure that the asset goes to him and that hopefully he doesn't commingle it. But there are provisions in the trust that can protect him. So what I would, it sounds like what you're saying in what we're hearing in this question, it does sound like the trust is the better option to protect this nephew. Skiles, is there anything you'd like to add?
I just want to say, when you're setting up trusts, you're protecting the beneficiaries from themselves. Mm-hmm. Sounds weird, but if that beneficiary is going through a divorce, like you said, they're going through criminal situations, they have a big lawsuit against them, they just ran into a bus full of kids or something, and now they got $1 million worth of lawsuits or whatever. the trust can protect that money from the beneficiary going through some bad situations. You can put language in there if they're, they have to commit to drug testing, they have to do certain things to be able to qualify to receive that money. You have more control over it if it's in a trust. That just gives that beneficiary all of those type of protections. So, and definitely there are places online that you can set up trusts, but I would definitely recommend finding an attorney to really explain and get your situation put into what exactly you need. When you're,
Is
especially
it
when you're looking
very
at trust.
expensive? Is it very expensive to do a trust con? Somebody told me that is very, very expensive.
It doesn't have to be expensive. There are some very complicated trusts that could be tens of thousands of dollars, and there are some fairly basic trusts that are much less than that. And every attorney is going to do something different from, maybe a couple of grand or give or take, and up from there. So I guess it really just depends on what you're looking at. But in general, a trust is going to typically cost less than going through probate. The probate cost is typically going to be more.
Correct.
Okay.
I just want to chime in on that with the value that it provides. If you're talking about significant money to the nephews, the trust is going to be the better approach. And you really just have to ask yourself, is it worth it to pay more to an attorney now to get it set up right and have an easier administration? Or if you have a will and it goes through probate, it's going to cost the beneficiaries a lot more, and you're not going to be there to prevent any will contest or any issues with spouses or anyone who shouldn't have access to the money. So if you're thinking about it from a value perspective, I think the trust is always going to be worth it to set up if you have a lot of concerns. I'm going to move on to question 8 from Ms. Marlene. I hope I said that right, or Marlene. I don't see your question in the chat. If you want to unmute yourself and ask your question. I don't see you.
I do have a question in the chat from Marlene. In a life estate where wife is the reminder of the state, can the originator change the reminder?
Can you repeat that question? Are they talking about a life estate or an enhanced life estate?
It says in a life estate where wife is the reminder of the state, can the originator change the reminder?
Yes, they can.
Well,
If it's a deed, if it's a deed on a property and the person has given a remainder interest to anybody, the remainder interest can be changed.
And to piggyback with that is, if it's an enhanced life estate, the person that created that can change it, just like she said. If it's a regular life estate, the remainderman is what it's called, the person that is getting the interest after the person passes away, they have to join in on that deed. So as an example, I own a piece of property. It's in my name only. I want to do a life estate deed that says when I pass away, I want the remainderman to be my children. Okay, so I've made a regular life estate that gives it to my children once I pass away. All you do is record a death certificate in the county, and my house now goes to my children. If I want to change that, and because one of the children has just gone off the rails and done all kinds of bad things or whatever, and I only want to give it to 2 of the children, I don't want to give it to all 3. If it's a regular life estate that I gave, all 3 of them have to agree to make that change. If it's an enhanced life estate, which has specific language on there that allows me to retain the ability to make that change at any point that I want, I don't need their permission. I can make that change down the road, take that 3rd child who's been a pain in you know what, and take them off of there and just give it to the other 2. Okay, so that you have life estate and enhanced life estate. I hope that answers the question. Did she come back on, or he? I'm not sure who it was.
I think that does answer the question. So difference between life estate and an enhanced life estate, make sure you know what you're looking at. I'm going to move on to number 9, Samsung SM. The question I see in the chat, my question is, can I give my timeshare in my will to my children. Yes-ish. Are your children over 18? If they're minors, not really. But if they're over 18, yes, but you can write that in the will, but it may not be the best option. Timeshare generally is real estate. Even though the actual property that you have doesn't seem real, it's usually now like ownership points, depending on what type of timeshare you have. But it is, you do sign a deed, it's registered somewhere. It will likely end up going through probate, just because again, it is real estate. And they are going to have to contact the timeshare company once the probate is done, because then the timeshare company is going to want their own process in, as far as, you know, perhaps signing a PR deed to make the official transfer. It can be a whole process. So if the timeshare is given in a will to adult children, it can be done, but it is a ticket to probate, and it can be pretty costly, and also take a lot of time. And in the meanwhile, someone will have to pay the maintenance fees, and may not be able to use the timeshare, just again, depending on the timeshare company itself. Skiles or Meenakshi, do you guys want to add anything on to that?
I'm fine.
Yeah, timeshares and probate equals a big pain. Let's put it that way. But yes, you're exactly right. You can add it in the will. You can, some timeshare companies may have some provisions for beneficiaries. I've seen that, but not all of them do. And if they're adults, you're obviously, they'll get the ownership of it, but just like Vanessa said, you'll have to do the maintenance fees and such. So again, trusts could also own timeshares too. So you could set a trust up to own the timeshare, and then the transition of that property is a lot more seamless after the parents pass.
Thank you, Kyle. Question 10, Ms. William Williams. When creating a will or estate planning, what or how I can make arrangements for it not to be challenged by anyone? Meenakshi, do you want to take this one on?
It's basically how good your attorney is, how good both parties have communicated with each other and have made the wishes known, what you want, and getting it correctly in the document. So it's a team effort between the attorney and the client.
Yeah, I've seen in the past, and in other states it's legal, that you can put a provision in your will that says, if my son challenges this will, then he gets nothing, right? So you could put that in your will. In the state of Florida, it is not valid. Okay, so I don't recommend that. I don't do that in practice. There are some states that it is valid, that you can put a challenge provision in there. But just like Mr. Rani said, is that you want to make sure it's properly executed. And if it's properly executed and properly documented that it's executed, then the challenges to a will being admitted into probate become very hard to overcome.
Yeah. So from that question, it sounds like perhaps you already have some concerns that a child or a family member may start some issues. I think the best way to do that, like Meenakshi said, is to communicate with everyone involved now what your wishes are. Make sure you speak with an attorney about creating a valid will. Make sure you come up with as many clauses to protect your actual beneficiaries and who you actually want to receive items. And you may also want to consider a trust in that regard. If you think that someone is going to contest something, if they're going to start issues, a trust does not go through probate. So you do have a means there for privacy. And if they try to challenge the trust, it can be pretty difficult. I mean, they can try, we can't stop people from doing what they're going to do, but there are provisions in a trust there to protect the beneficiaries as well. So what you might want to think about, kind of what we talked about earlier, as far as like the value now versus the value later, if you take the time now to set up a strong will, title things the way they need to be titled to ensure a smooth transition when you pass. it may be better for your beneficiaries to get access to what you want to leave to them versus perhaps going through a costly and really emotionally draining probate. I do see that.
I'd just like to add one thing. We have been talking about creating trusts to avoid probate, but trust is only good when you have actually transferred the assets into the trust. So if one of the property or asset has not been literally transferred into the trust name, that property will go through probate. So that precaution needs to be taken care of.
Perfect. I've lost track of my numbers. I was doing so good. Is next up Miss Peggy or is next up iPhone? Sorry, Rebecca.
No, that's okay. It's Peggy.
Peggy. All right, Miss Peggy, what is your question? How can we help?
So in the chat, it says, does a life estate, as mentioned earlier, in a will sufficient for exchange of property? Would you still advise a trust over a life estate than a will?
So that's kind of what we were talking about earlier with the life estate. So yes, life estate does transfer the property after somebody passes away, but there are the advantages of the trust that can be seen during your lifetime as well. If you become incapacitated during your lifetime, let's say you get a bad car accident or have a medical issue, the trust is the owner of the property, and the trustee can kind of take over and manage it for your benefit during your lifetime. And then after you pass, it would then go to the benefit of the children. Do we recommend a trust over a life estate and a will? It depends. I hate to say the lawyer answer of it depends, but it depends on all the other factors that really come into play. What other assets you have, how much control you want to have. There's also questions about mortgages. I have a lot of people that if they still have a mortgage on their property and they put it in a life estate, the mortgages sometimes will accelerate your mortgage, meaning you have to either pay it off or refinance it. And because they don't like life estates, it's a weird type of ownership in today's world, let's put it that way. Used to be the standard back in the old days, but nowadays it's a very weird ownership. So mortgage companies don't like them. If you ever want to refinance, you may have to get it out of the life estate, refinance it, and then put it back into a life estate. I've had to do that before with some clients. It's just been, it depends on the situation and everybody's going to be a little different.
Yeah, I completely agree. It's such a case-by-case situation. The next question that I have is number 12, iPhone. Is any property under a revocable trust ever included in probate process? So to what Meenakshi was saying earlier, it really does depend how things are titled. So there's two parts to creating a trust. The first is the actual agreement, actually creating this trust. What does it say? What are its terms? And then once you get it signed and executed under Florida's formalities, then you have to title your assets into the trust. The trust has to own these items. And so if the trust is not, like, let's say you create this trust, but you don't go through the second part and fund your trust, then everything is still titled in your name and the trust has essentially failed. What we'd recommend in that regard is to make sure you also do a pour over will. This is a will in Florida, but what we write in this will is that we want everything to go into the trust to pass away. This way, you'll still end up in probate if your items are not funded into the trust, but we can still find a way to pour your assets into the trust. Skiles or Meenakshi, do you want to add on to that one?
No, basically it's the same thing.
Yeah, and then just a caveat of that is assets from a trust can be pulled into the probate in the litigation aspect of it. I see it when things do not go for the spouse. So in Florida, we have the spousal elective share, which means that the spouse can elect to receive 30% of whatever the decedent's property would be, including life insurance, property that's in a revocable trust, property that transfers outside of probate, like a life estate deed or joint survivorship deeds. joint bank accounts, all of that good stuff, the spouse has the ability to elect to receive 30% of that. So I've seen it where the married couple, they've been away from each other for 20 years, but they never got divorced. And now the guy gives all of his money to either his kids or his new girlfriend or whoever, right? A charity, doesn't matter. He gives it to somebody other than his spouse, and he might have millions of dollars. Spouse can then come in and say, I'm supposed to get 30%, and all of that can get pulled back in, and that spouse can receive that 30%. It's a long, drawn out process. And so trusts are part of the estate planning process. It's not, you can't avoid everything. There's still laws that are in place, especially marital laws, that can't get around some of those kind of things. But it's part of the whole process to consider everything. And again, that's why you need good person to chat with to kind of make sure you're protected properly. And you know, if you're should get a divorce, just get the divorce, you know, kind of thing. And it solves a lot of problems sometimes, but might open another can of worms sometimes too. So just depends on the situation. I hope that answers that question.
All right. That almost was the end of our questions, but I do see now Natalie asks, can previous spouses grab money or estate?
So I'm gonna let my husband ask these questions because this was his question.
Okay.
Hello, I'm not Natalie, I'm Mike. So
Yep.
I had a previous marriage of 13 years that was 20 years ago. Does she have any way of reaching in and
rights?
making a claim on my estate?
Was
when I
she,
pass?
are you divorced?
We have been divorced for over 20 years, yes.
If you're divorced, then it ends the situation. Whatever was your property settlement in divorce decree, that will govern.
Okay. So the transactions that occurred in my original divorce were it, and she has no way of getting more from me when I pass.
No money,
Unless-
no social security, no real estate, no nothing.
Well, Social Security is a different thing. It's based on how many years you guys were married, and she would be entitled to that. But unless you have joint property still in joint names and you haven't done any quitclaim deed.
No, nothing in joint. Okay.
Okay.
Thank you.
Yeah, the only two things I would add is that as long as the marital settlement agreement has been satisfied and there's nothing in there that needs to occur. And the only other thing, the only other time I've seen spouses that have come back into an estate would be when there is no other family members or no will to take anything. Because the state of Florida does have a statute for intestacy, which means you have no will, that says that your current spouse is beneficiary, your kids are beneficiary, grandkids, etc. Goes back up to parents, brothers, sisters, nieces, nephews, goes back up to grandparents, uncles, aunts, cousins. But there are times when some people have none of them. So if you have nobody from grandparent down that is a relative of yours, a blood relative, and then your former spouse is the next in line. That's a Florida statute that's in there. I've personally never had to do that. I've never had that. I've done hundreds of probates, but I've personally never had it gone down that far. But that is in the statutes. Other than that, I don't really see any other way that prior spouses really come back into probate.
Thank you.
Great, thank you, Natalie, and thank you, Skiles, for that. I don't see any other questions, but I'm going to go ahead and just open the floor if anyone wants to raise their hand or ask a question in the chat. This program is supposed to go until 7 and it's currently close to 6:30. So unless anyone asks any other questions while I ramble on, if there are no other questions, then I'll make sure Rebecca gives me the green light to conclude our program.
Looks like Natalie has her hand up again.
So I see it's Skyle Jones, and I don't want to mess up your name, Minashki.
Yes, Meenakshi
What's your
You can-
last name?
Hirani.
Okay, I just want to make sure that I had both lawyers well documented.
And Vanessa Clark, she's also an attorney as well.
Okay, Vanessa,
Yeah.
thank you so much. I appreciate it.
Of course. I do see a hand raised from Miss Willia Williams. Miss Willia, if you want to either unmute yourself or write your question into the chat.
Yes, hi, everyone. I just want to know how to get the ball, I came on 10 minutes late, just at the end of the presentation, the PowerPoint. That's why I placed, the inquiry about emailing me the presentation. But I guess my question would be how to get started on the living will and the power of attorney and the trust, maybe. I just need to know how I can get started, basically. Get the ball rolling.
Sure. In the chat, there's links to the self-help center at the courthouse, but they don't have the estate planning documents there. Really, to get started would just be to contact an attorney. There's a number of different ways to find online help, but just like we told everybody today, that's one avenue. Best route would be to get some personalized advice from someone. You're welcome to contact us. There's plenty of other attorneys out there. Hopefully, and again, everybody's got their own flair of how they do certain things, and just finding one that works for your schedule, one that works for where you're at, one that works for in your price point as well. And Rebecca just put in the chat some of the other links as well. And of course, the Orange County Bar Association, which is our local bar association, we do have a lawyer referral and information service. I'm actually the chair of that committee right now. But the lawyer referral and information service has a list of attorneys in the local area that when you call them, they can match you up with someone and they'll agree to talk to you and give a free consultation to you. And they'll also, if they do charge you anything for what's happening, they do give money back to the Orange County Bar Association, which goes into providing more legal aid to the community. So it's a way to give back to the local community as well. Little
Thank
plug
you.
for our lawyer referral service as well, and the phone number is in the chat as well.
I appreciate that.
And they put the Facebook page on the lawyer referral service on there as well. So please like and share and all that good stuff.
And I do see there is another question from iPhone. Can the marital domicile be transferred to a non-existent corporation without consent of spouse? Then spouse dies, and should the marital domicile be included in probate? So there's a lot of parts to this question. If you have the home titled in, actually, I'll say this, I'll get us started and then I'll make sure I get your input on this one as well. So if the marital home is titled in both spouses, if it's titled under both, you're not going to be able to transfer it without both signatures. Both signatures will be required. So if the spouse dies, should the marital domicile be included in probate? So that's going to depend on if it's homestead or not. If the marital property is homestead and a spouse does pass away, if it's titled under both, it's usually considered a tenancy by the entireties type of deed, which comes with a right of survivorship. So whichever spouse essentially outlives the other would be able to take the property. Skiles and Meenakshi, if you guys want to chime in from here. Do you have anything you want to add?
Yeah, I'll let you go ahead, Meenakshi.
Another thing, just the idea of transferring something to a non-existing corporation itself is a red flag. You're exposing yourself to a lot of litigation, other side attorney fees and stuff like that. So I wouldn't recommend transferring it to non-existent corporation.
That's a good catch. So in what Vanessa was talking about as to there are provisions in the Florida Constitution that says you cannot transfer your homestead property to anybody other than your spouse without their permission. And there is the statutes as well that talk about how to get that permission. So since we have some time, I'll give you some examples, right? So if I own property by myself and I'm married and I want to give that property to my children, to a trust of mine, to a company, whatever, an LLC, whatever it is, I cannot write a deed that gives my property away without my spouse's permission. Now, that is a right that the spouse has just by virtue of being a spouse. There's nothing that you have to sign to say that. That's just a statute that says well, it's in the Constitution and their statutes that say that you can't give your property away, or your homestead property. If I have a rental property that's in my name, I can give that to whoever I want, right? I don't need my spouse's permission, but my homestead property, where I live or where my spouse lives or where somebody in my family lives, I cannot give that away without my spouse's permission, okay? Now, if we both own the property together, I can give my half away, but I can't give the whole, the other half away without spouse's permission. So there's a number of different things there as well. Again, just make sure you get the proper advice on that. And I hope that answers the question. Was that the rest of the question there?
Yes, it was that the two parts, then the spouse dies, and should the marital domicile be included in probate?
And just to add to it, the consent would be by spouse joining in on the deed to transfer the property.
This is a complicated question. So a very good reason to contact the Orange County Bar Lawyer Referral Service Program, just to make sure you do speak to an attorney. A lot of the advice that was given is just assuming that you have the homestead. So you just want to double check and make sure that you've got homestead, because the rules are different if it's homestead or if it's not homestead, and just depending on your specific situation. I'm going to move on to question 14 from Samsung. It says, have a home with my uncle and he died. Sorry to hear that. Do I own the house 100%? We were both on the deed. Or do I have to probate his percent? He had no will and a divorced man. I'll go ahead and get started, and then I'll pass on to Skiles and Meenakshi. So to give you the lawyer answer, it depends. You want to check to see what the deed says and how it's titled. So if you were both on the deed, does the deed say that it's a right of survivorship, or does the deed just say that you own it 50-50? If you own it with a right of survivorship, then it would appear to me that you do own this house outright. However, if the deed says that it's a 50-50 tenants in common, at that point you would have to do a probate to essentially have his name removed from the title. And Skiles and Meenakshi, I'll let you guys also chime in on this one.
And if it's titled as tenancy in common, you still keep your 50%, but your uncle's 50% will go based according to his will, if there is a will.
Right, and I see your comment again. It says warranty deed at the top. That's fine. It's just identifying that the seller to you is warranting that the title was good. Most of the time, what we see, if me and you are owning property together and we're not husband and wife or married couple or whatever, then they're going to just put our two names on there. So if me, it'll say Skiles Jones and Vanessa Clark, we're not married, we just own this property together. The default is tenants in common. That's the type of ownership we have. It doesn't have to say that. It doesn't have to say 50% ownership. It doesn't have to say anything else other than seller is giving the property to Skiles and Vanessa, and it puts our addresses typically on there and that kind of stuff. The default is tenants in common, which means that when your uncle passes, if you're a tenants in common with him, your half, just like Ms. Harani was saying, it was that your half is yours. His half would have to go through the probate process and would go to whoever his heirs would be. And that's a whole probate question of where his heirs are. His kids, his parents, brothers, sisters, whatever it is. Hope that answers your question.
So-
Yes, tenants, most likely tenants in common. If it doesn't say any kind of survivorship language or anything like that, it would be tenants in common.
The right of survivorship does have to be expressed on, if you're not married, then in order for there to be any right of survivorship, the deed should say it. It's not implied.
Or in Florida, even if it says joint tenants, then by default, it will be with the right of survivorship. But it's always better to mention it because other states, they require that language specifically stated joint tenants with the right of survivorship.
Every little word has a meaning in there. That's kind of how it goes.
All right, I don't see any other questions. It looked like Samsung was our last one. I will again open up the floor to see if anybody else has any questions, if anyone wants to write in the chat or just come off mute and ask your question. Hearing nothing, I will turn it over to Rebecca to make sure I have the green light to close out our program.
Yes, I do not see anything else. I do have announcements, but I can go after you.
Okay, thank you. All right, so I'll go ahead and start the conclusion. Thank you for attending our Ask a Lawyer event. Please contact the Orange County Bar Association's Lawyer Referral and Information Service to be referred to an attorney for a free consultation of up to 30 minutes. You may be charged for speaking with the attorney or any services provided beyond the initial consultation.
All right, thank you so much. We want to thank all of the lawyers, attorneys, and to the Orange County Bar Association for organizing tonight's event. Thank you to our attendees for joining us tonight. I do want to mention that I will be sending an email following this event with information and resources that were provided in tonight's event. Please note that if you did miss any part of tonight's event, it is recorded, so you can go back and refer to the recording. It's going to be on the Orange County Lawyer Referral and Information Services Facebook page, which I'll also include in the email. So you'll have all the information you should need in this email that I'll send to you guys following today's event. And we want to thank everyone so much for your time. Thank you again, and we will see you guys next time. Our next one that we have is in October, on Tuesday, October 24th. And that's going to be, the topic is going to be landlord, tenant, and real estate law. So I'm going to put this into the chat. Again, I'll add this to the email, but just so that you have it. That concludes tonight's event. Hopefully you guys all had your questions answered. And if you need anything else, please let us know. Thank you.